Good morning. Welcome to this second day on the conference dedicated to Alberico Gentili. I would like to thank the organizer of this two-day conference, and I apologize for not being here yesterday. It is an honor for me to chair this session and introduce my estimated colleagues, Attila Tanzi, Christian Tams, and Serena Forlati. The starting point of our reflections today is the role of internationalist scholars in the construction and development of international law. Publicists have played an important role in the formative period and growth of international law. The writings of Suarez, Gentili, Grotius, and Vattel, for example, had a profound effect on the structure and content of international law. The teaching of publicists were regarded as highly significant until the 19th century, when legal decision and literature were littered with reference to them. Teaching of qualified publicists have often been used to demonstrate widespread state practice, interpret a treaty provision, demonstrate a general principle of law, explain the practice of court and tribunal, provide general context for a specific point or case, demonstrate existence of a rule of law, and advocate for a change in the law. By the end of the 20th century, however, it was widely believed, including among the publicists themselves, that their teachings had become far less influential for the new role played by international courts and tribunals. Many permanent courts specialized in particular areas of international law. The category of publicists can be broken down into at least three types: individuals, authors, expert groups, such as the Institut de Droit International and the International Law Association, and ad hoc expert groups, and entities that have been empowered by states to conclude studies, such as the International Law Commission. All these categories will be analyzed by our speakers to define the role they have played in shaping the international order over time. So now I give the floor to Professor Attila Tanzi, full professor of international law at the Alma Mater University of Bologna, advisor to the legal service of the Minister of Foreign Affairs and International Cooperation of Italy, and president of Italian branch of International Law Association. His expertise in international law, with an impressive track record in both practice and academia, enjoys worldwide recognition. Sorry. Thank you.
Well, thank you. Your very generous introduction. I thank the organizers for the invitation. I would have thanked you anyhow, but I thank you wholeheartedly after having spent the first day here. I have learned a lot, and the place is particularly conducive to learning and understanding, also through the help of the best colleagues around that can teach you something, if not a lot. I will try and be a bit shorter than originally meant, also because of the rich introduction by Andrea. thanks to yesterday's discussion and to the fact that I would be standing with my colleagues in between now and the Lectio Magistralis, which I very much look forward to attending and listening to. Of course, a caveat, inevitably I will address issues that bear on the subject matter addressed by other speakers. I'll try and self-constrain myself to the maximum, and particularly on Serena's presentation, I will try and trespass to the inevitable minimum. By way of conceptualization, allow me to venture to say that the topic of the contribution of scientific institutions to the construction and development of international law is particularly germane, or at least I regard it as particularly germane, to the work and life of Alberico Gentili, whom we celebrate today. For he was a precursor, and we've heard it yesterday and this morning again, that he was not alone, of course, in grasping and stressing the central function of that internationalists play in the building of the international legal system as a conceptual and linguistic tool for the purpose of the conduct of international relations. Some today would add to the role of building the international legal system that of its maintenance and conservation. Others would add that of promoting change and reform. Others, again, Marty, would add promotion of its critical knowledge and critical knowledge of its use, possibly from an international sociological standpoint, amongst others. The latter, as I see it, is a perspective about international law from the outside, even though propounded by insiders, and not an international perspective, a perspective about its making, changing, and implementing from inside. If I have to express at the outset the standpoint of my analysis as a correct political scientist would do, my standpoint identifies with a legal perspective, that of a view from the inside. I may admit to the inevitable lack of neutrality that may be involved in explaining a system from inside as being part of it, and I appreciate critical analysis of the system and its functioning from a sociological, historical, and philosophical standpoint. And I willingly identify with the lawyer's view about the international law process, thus accepting its convention, or its linguistic code, if you will, in some kind of an intellectual, cultural dédoublement fonctionnel. I may sometimes use historical, sociological, economic, or even political categories in addressing legal issues, but I use them as conceptual instruments, or even instruments for purposes of legal analysis. Social and political scientists may do the same in the reverse perspective. However, from one perspective or another, especially as academicians, but not only as such, I believe that we all partake in the inevitable process of being characterized by the fundamental tension between stability and change, that is, construction and development. As I see it from the international law perspective, international scholarly institutions are precisely entangled with the systematization and promotion of a balanced process of normative calibration between legal stability and change. It is against this backdrop that Gentili's motto, Silete theologi in munere alieno, appears to be not only a vindication of the autonomy of law from ideology, at a time when ideology, identified with dogmatic and axiomatic values determined by the religious doctrine, but constitutes the political manifesto of a cultural project. Such project being the construction and development of international law, thus largely intended, at least until recently, as a creature of internationalists, in the sense of a language system, a system of beliefs, signs, and meanings powerfully propounded by international scholars. Law as language is a configuration that has been repeatedly evoked yesterday. In 1984, Judge Robert Jennings of the International Court of Justice, judge there, wrote, and I quote, "In a society of states much divided by ideologies, by religion, by poverty and wealth, by power and weakness, by size, by history, and by geography, it is well never to lose sight of the fact that the one vocabulary of ideas that they have in common is public international law," unquote. Those were the days characterized by the major East-West and North-South divides of the Cold War and decolonization. Still, whilst in pursuit of different substantive social, economic, and political interests, different factions would interact, clash, and negotiate, all relying on generally shared legal tools, each in the pursuit of their own interest, but very much based on the fundamental legal concepts and codes, systematized, illustrated, articulated, propounded, and disseminated by that invisible college of international lawyers, as Oskar Schachter would say in 1977. Today, such a configuration of international law as a system of beliefs, theorized and propounded by scholars, is not generally shared by sovereign political actors and their representatives, divided between nationalism and multilateralism, and is no longer generally shared within the international law scholarship. We are in a divided world which is incommensurably more divided than in 1984, when Judge Higgins wrote that passage, or in 1986, the year of the first edition of Antonio Cassese, International Law in a Divided World. Much more acute and pervasive divisions bear significantly on the sense of the role of international scholarly institutions today. International scholarly institutions that my presentation addresses are basically international NGOs dedicated to research and disseminating international law, but also to promoting its development. To that end, oftentimes such institutions engage in exercises aimed at the written consolidation and codification of bodies of international law or specific aspects thereto. Let me make two prominent examples. The International Law Association, founded in 1873, and the Institut de Droit International, also founded in a lucky year, 1873. Its role in the international law process has been extensively and critically analyzed by Professor Koskaniemi, and given also my affiliation to the ILA, I will linger a little bit more on the ILA, but let me recall that in 1904, the Institut won a Nobel Prize for the promotion of interstate arbitration as a means of peaceful settlement of disputes. Nowadays, arbitration as a peaceful means of dispute settlement is taken for granted. But in 1904, that was quite a novelty. Even prior to the 1907 Second Hague Peace Conference. It was indeed remarkable. When I say exercises aimed at the written consolidation and codification of bodies of international law, you have to think of expert lawyers, often scholars and practitioners at the same time, discussing on which may be the best written formulas they believe may express the state of existing law on any given matter, or which they believe is the normative direction the international society is taking or ought to be taking when it comes to regulation. In their turn, each lawyer substantiates his or her proposals by referring to grounding authorities, that is, case law, international conventional or diplomatic practice, comparative domestic, legislative, executive, or judicial practice, where available and relevant. Unlike the International Law Commission or the United Nations Commission on Trade and Development, which represent state-empowered bodies, the twins institutions, the ILA and the Institut de Droit International, constitute private expert groups alongside the Hague Academy of International Law, the Harvard Research Institute, the American Law Institute, and the Asser Institute. They are self-empowered. The authority of these entities is independent from an official mandate from sovereign entities and rests only on the quality of work, authority, and representatives of its members, which may beg the question sometimes, and I will elaborate on that in my written contribution to the proceedings of this meeting. Focusing on the ILA, comparing membership requirements, for example, with those of the International Law Commission may help. Article 8 of the Commission statute reproduces in almost identical terms Article 9 of the ICJ statute, providing that, quote, the persons to be elected to the Commission should individually possess the qualifications required, which may beg the question, and that in the Commission as a whole, representation of the main forms of civilization and of the principal legal systems of the world that should be assured. Similarly, the ILA has the peculiarity of having a regional structure. As at present, it counts 66 national within different regional branches. It boasts 4,500 members, showing significant diversity in cultural and professional backgrounds as it ranges from lawyers in private practice, academia, governmental officials, and the judiciary, but acting in their personal capacity. Non-lawyers, experts from commercial, industrial, financial spheres, and representatives of bodies such as shipping and arbitration organizations and chambers of commerce. The scientific activity of the ILA revolves around activities of committees established, and I quote, to carry out research on selected areas of international law and to prepare reports for discussion at the biennial conferences for purposes of adopting recommendations by the conference plenary, unquote. Now, we have to look at the authority of its resolutions in order to test the effectiveness of their contribution to the process in living up to the expectation of contributing to the construction and development of international law. A contribution which is now forthcoming in the first issue of the yearbook of the ILA Italian branch aims at taking stock of the influence of the ILA resolutions over a period of roughly 20 years. Reference has been made to cases before the ICJ, the International Tribunal for the Law of the Sea, UNCLOS Annex 7 arbitral tribunals, regional human rights courts like the Inter-American and European Courts of Human Rights, investment and commercial arbitral tribunals, as well as, to a limited extent, to municipal courts when they apply international law. The selected cases focus on 5 macro areas: procedural law, human rights, investment protection, state jurisdiction to adjudicate, delimitation of maritime boundaries, and international water law. Except for the first topic, the analysis shows that international courts and tribunals are generally reluctant to openly cite the work of the ILA and its resolutions. but they are so with regard to other pieces of scholarships in general. Even when they agree on the merits and their arguments surfaces in between the lines of their adjudicative decisions. In this sense, the ICJ is self-referential. International courts and tribunals seem to be indeed jealous of their own jurisdiction, and except in rare cases, they do not wish to endorse the authority of anyone else who might challenge its own primacy in their knowing the law, in their iura novit curia prerogatives. They know the law and should know the law. No one teaches them the law. They have learned it before becoming judges, probably. But the court usually takes implicitly on board the parties' arguments who have been pleaded by counsel that are replete with references to various authorities, more often than not, including reliance on ILA and IDI end product of their workings. Greater attention towards teachings, and particularly those of the ILA and IDI, is paid by judges and arbitrators in their separate or dissenting opinions. In an interesting study from 1912, the author points out the numbers, which I will spare you of, but you will find in my written piece. It is understandable that being in the minority, they feel the extra need to substantiate their individual stance in relation or in contrast to the majority's view. Procedural law is an area where ISI's resolutions stand out as exceptionally quoted more frequently, and this is understandable, for not always the applicable procedural rules cover all the procedural issues that may be encountered during proceedings. Thus, reliance is often made to external authorities, such as soft law guidance from the ILA, the IDI, but also the International Bar Association or ANCITROL. Also, the use that international courts and tribunals and parties to the dispute, counsel, actually make of ISI's works. Most frequently, it is for purposes of clarifying the scope of application of a norm of international law, more than demonstrating its existence. One may recall decisions interpreting the principle of res judicata and identifying the requirements for its application. In the same direction stand cases dealing with the scope of application of the customary rule on state immunity from civil jurisdiction, in particular as to whether it applies to compensation claims for damages deriving from gross violations of human rights. There are cases where the works of international scholarly institutions have been used to clarify the status of a norm rather than its contents. I would like to quote a milestone case. It's an investment law case, Grand River Enterprises versus United States, in which the ILA works have been relied upon to substantiate the customary nature of a rule requiring consultations with indigenous peoples on every project significantly susceptible of affecting their rights. Now, all that being said, scholars should avoid self-satisfaction. For as Hobbes warned us, autoritas non veritas facit legem. And there is no doubt that this autoritas, decision-making and law-making power, is still primarily vested in states, despite civil society is increasing in finding forms of recognized participation in the international law process. The research just referred on the impact of international scholarly institutions on international case law shows some recognition for the authority of knowledge. I will probably end within the next 5 minutes. We could then rephrase research and authority in the title of my presentation, the binomial delimiting the scope of this inquiry, as epistemic authority versus political authority, thus also highlighting the dialectical tension that binds them. Legal science is, or better, scholars of international law are constantly engaged in relentless work of domestication, civilization, and humanization of the international community. Far from being a place of ironicism and high ideals, the international community, we heard it from Carlo Galli yesterday, per se corresponds rather to a space of force, violence, and oppression, in which there is no other law but that of the strongest. In contrast, the epistemic authority of international law consists precisely in the capacity that internationalists have with their arguments to influence and harness chains of command and choices made by decision makers, forcing them at least to justify their own determinations through the language of international law. Here, international law from a symbolic universe becomes a system of belief, an instrument of cultural hegemony with which internationalists try to imprint power with a possibly rational form. We are living in very difficult times for international law today. But I do not regard this as a problem of international law, but as an international political problem about the use of the law in politics and society. When corruption and organized crime thrives in a given society, I believe that it is hardly ever so because the criminal code is wrong, but that there is something wrong in that society and political fabric at that point in time, and the law cannot change society. Good society may make good law, but good law can't make society good. And let's not fool ourselves. It is of little consolation that Putin on 22 February 2022 relied on Article 51 of the United Nations Charter or on the Genocide Convention, both to justify its invasion of Ukraine. And I often go back with my mind to those who studied and promoted international law in 1938 throughout 1944. I believe they were right not to give in to desperation and to try to stick to and preach the rule of reason in time of madness. Thank you.
Thank you for this clear, interesting, and brilliant presentation and that gave us a comprehensive framework of the role of scholarly institutions and their authority in the development of international law. Now I give the floor to Christian Tams, Professor of International Law at the University of Glasgow, where he directs the international law, the Glasgow Center for International Law. He has published 70 books as author and editor, and several articles, books, chapters, and notes on questions of international law, European Union law, and German constitutional law. Thank you.
Andrea, that's very kind, the introduction. It's wonderful to be here. Good morning to everybody. It's my first time in San Ginesio. I'm enjoying every minute of it. I have a close friend, Paolo Palchetti, who has been involved in the organization of previous events and who told me a lot about San Ginesio and the Genius Loci that you spoke about, Luigi, yesterday. I also recall conversations with a younger colleague, Lucas Lima from Brazil, formerly a doctoral student at Macerata, and I'm glad to say that I agree with all they say. It's wonderful to be here, and I will be glad to join the discussion with them on a more equal footing now that I can talk to them about what I have experienced and not just listen to their stories. So thank you for the invitation. It's a privilege to be here. My presentation today continues our theme of the morning, internationalists and their influence on the development and construction of international law, compared to what we have heard from Attila in his first discourse. My focus will be on the individual scholar. I think that was one of the categories you mentioned, Andrea, in opening. My focus will be, like Attila, on the influence or impact of scholarly interventions on international law in a relatively narrow sense, understood as a corpus of rules and processes that bind subjects of international law, mostly states. So I'm not looking at scholarly interventions and their influence on our understanding of international law as a discipline. So you could say that's a relatively orthodox focus, but it's relevant because it means that from that orthodox focus, I start with something that Andrea said in opening, a common perception that the role of scholars, the impact of scholars, and the relevance of scholarly interventions on the development of international law has gone down. We credit regularly the Grotiuses, Gentilis, and others with having formed, shaped, influenced of international law, and that may be true or not. But the common perception is that these days are over. We may be standing on the shoulders of giants, but are dwarfs. And of course, that's probably correct in some ways, but it's also often put in very categorical terms. Let me give you two quotes to just validate, I think, what Andrea said in opening, the common perception. There's a recent book by a Norwegian scholar, Tore Helmersen, on teaching and the International Court of Justice, and it has this casual remark in the introduction. Teachings were more significant in the past. It's not maybe a good way of opening the book and attract readers to it, but that's stated matter-of-factly, as if it was a truism. And even a Georgian colleague of ours, Alexander Orakelishvili, who writes and writes and writes, and sort of not a year without a new book, he says there's the relative demise in the role of scholars in international law. So there's a lot of reason for caution as I approach my topic, and I don't think I would disagree with these statements, but what I want to do is perhaps nuance them and offer sort of a window towards exceptions, exceptionally impactful interventions, so to say that the demise is indeed only relative and not complete. And I want to influence this by telling you two stories, perhaps, or vignettes, giving you vignettes of where international law has been shaped significantly by scholarly interventions. But before I come to these stories or vignettes, let me, if you want, lay the groundwork and I think go some way towards affirming the general perception that the role for scholarly interventions has shrunk in international law. And I don't think, I mean, of course you would say that, I don't think it has to do necessarily with the quality of scholarship. None of us can pretend to be a Gentili or a Grotius, but that's probably not the reason why our work is less impactful. It has to do with changes in the structure of international law. And I would say there are two trends in particular, which I'm simplifying, but hopefully usefully, that explain the relative decrease in relevance. The first is the rise of legal formalism with the development of a doctrine of sources. And the second is the professionalization and expansion of international law in the 20th century and the rise of almost like a lawmaking industry. I'll say a word about each of these 2 points before coming to the stories that suggest that there's still room for scholarly impact. Now, first of all, legal formalism and the doctrine of sources. International law is curious because none of the canonical texts defines, if you want, the legislative process in clear terms. What international law does is define potential outcomes of such processes. There's relative agreement on the sources of international law, and treaty and custom dominate. What is absent from the sources of international law is anything that directly refers to scholarship, there's a reference, and it's been quoted already. Serena, I think, will speak to this a lot more, to the teaching of publicists as a subsidiary means for determining rules of law. And perhaps there's a window there. But clearly, international law's doctrine of sources does not list teachings as one source, but focuses on other products, other outcomes, treaty and custom in particular. So that's the first trend. Perhaps as significantly, I think, are developments in the reality of international lawmaking, and mainly in the course of the 20th century. These have, if I'm putting it somewhat simplistically, pushed scholars and their impact to the margins. There are many other agents of legal development which work tirelessly towards the development of international law and are much better placed. And if we go through a list, we can see it almost like a checklist of the major trends, the major changes in the development of the institutional setup of international law in the 20th century. There's a massive move towards treaty drafting, including multilateral treaty drafting, which produces law by the minute, pretty much. There's the rise of foreign office departments, which engage in the construction and development of treaties as their professional métier. And we have that in 200 states with different capacities, but it's present in every foreign office. We have the establishment in the course of the 20th century of bodies that are tasked to work towards the codification and progressive development of international law, some of them private, but also public bodies, UNCITRAL, the ILC, lawmaking commissions within specialized agencies. We have the rise of international courts and tribunals, another big feature of 20th century international law, which settle disputes, but en passant, no doubt, clarify, specify, mold, shape, and develop international law, and do so probably with more authority than an individual scholar. And we have the rise of treaty regimes with their own institutions, which are almost constantly in the business of updating their treaty. COPs, MOPs, conferences of parties, specialized commissions, which are constantly in session and do nothing but elaborate the 25th annex to the 27th Framework Convention, which is supplemented by 27 protocols. So there's a constant exercise in law production by entities that are tasked to do so, or as in the case of courts, expected to do so within limits. So lawmaking in international law today, unlike 500 years ago, is a bit like a busy town square where you have hundreds of craftsmen and craftswomen hammering away, producing this bit of law or that bit of law. And the scholars who may have a role to play are sort of somewhat squeezed to the margin, perhaps having a coffee in one of the coffee houses at the side of the place, occupying a nice place, but perhaps not at the center of the productive activity. It's a crowded place, and scholars are squeezed out. If that is too simple or simplistic a vision, then let me quote one of the wiser writers on the process, Nicholas Onuf, Global Lawmaking, a book a generation old but very fresh. He speaks, and I'm quoting, of the bureaucratization of foreign policy in the 19th century, the rise of diplomat bureaucrats who had replaced writers as integrative features of the international legal system. He says that jurists began to replace writers as lawmaking catalysts, and codification moved from being a private affair to an interstate exercise. What is the outcome of this, or the upshot? Again, Onuf, the chronic upheaval of the 20th century has all but destroyed the credibility of the legal order invented by scholars. End of quote. So that's the backdrop. How do we move on from here? I wanted to tell you a more positive story, after all, about the role of scholarly interventions. Kammerhofer, Onuf, others seem to leave little room for that. But the statements are perhaps too categorical and can be nuanced. And I think in beginning my attempt at nuancing them, I take my cue from something that Martti Koskiniemi said yesterday when he spoke of the power of lawyers and law to shape our imagination. Now that is a much bigger theme. I want to only pick up on a small point of that, and perhaps also am influenced by something that another colleague has written, Jean d'Apremont, who envisages scholars as grammarians of international law. Whichever our image, whichever our metaphor, I think the key point is the same, that legal scholars can exercise influence by acting via others, by influencing the existing lawmaking processes, even if their writing are perhaps in and of themselves not so influential. They can prepare the ground and act indirectly through others and significantly. Now, in passing, this is of course not peculiar to international law. We study this all the time, and I think the most obvious connection is between scholars and courts, that in very many areas of law, we look at the influence of scholarly writing on judges and then via judges into the shaping of a legal system, domestic or international. This may be the most obvious path towards influence. Court decisions relying on scholarly work amplify the voice of scholars, imbue scholarly work with the authority of the court decision. This is something that's well known. It's also deeply problematic because, of course, it means that so much of legal writing really is writing for courts and judges, which you could say limits the creativity in the genre, is maybe one factor why much of legal writing is so boring. But here we go. I think it's a path to relevance in a system which fetishizes courts and judges, as law does, and why not? I mean, they are peculiar to our system of order, so why should we not focus on the judges? I want to look at another form of influence, also indirect, not via court decisions, but at scholarly work that has initiated more concerted, coordinated lawmaking codification projects. This is not as common, but it's quite relevant. And as I said, I want to tell you about two examples, two vignettes. One of these vignettes is pretty grim, the other not so. And I'll start with the grim one so that we have an uptake in terms of mood. Both have pretty impressive scholars as protagonists, and I think they bring out what I want to get across. So the grim story first. It's a story of how international law responds to a horrific crime, the extermination of the Jews of Europe. The crime we now call by one or two names, Holocaust or genocide. And more specifically, it's about the role of one scholar who was central in shaping an emerging international law regime against genocide. So my first vignette is about Raphael Lemkin. The backdrop is well known, if horrible, and I will briefly summarize it. The extermination of the Jews of Europe began to be planned soon after the National Socialist takeover in Germany from early 1933. And in retrospect, we clearly see how discrimination gave rise to systematic persecution and eventual destruction. Concentration camps became extermination camps. And in retrospect, we see the trajectory with relative clarity. We identify the waypoints, the Nuremberg laws, Reichskristallnacht in November 1938, the Wannsee conference where protocols were drawn up by bureaucrats to map out the final solution. But hindsight is always 20/20, and the onlookers, the witnesses, struggled to process the information. They knew less, they didn't perhaps believe rumors, and perhaps they were complacent. Now, Lemkin was not complacent, he was alarmed, and he sought knowledge where others preferred ignorance. He was a scholar and a practitioner, a prosecutor, a criminal lawyer from Poland. And he had long thought about crimes against groups, long before the final solution was put in place. In 1933, Lemkin presented a report to the International Conference for the Unification of Penal Law, one of these semi-official codification institutions that existed. So in 1933, March 33, independently of any Nazi policies, he suggested that international law should expand the principle of universal criminal jurisdiction to cover what he called the crime of barbary. This crime didn't exist. Lemkin sought to define it. It should cover conduct directed against racial, religious, or social groups, massacres, or pogroms. But the Unification Conference that listened to his report felt this was premature. It felt there was no boundary established for this crime, it was too vague, and there was insufficient practice. And so the report was shelved. Now, 10 years later, things took a turn and took a very different turn. By then, Lemkin had fled his native Poland and taken up a position in the US at Duke University. From 1940 onwards, once he had reached the US, he collected data and information on the prosecution of minorities and by German forces and Eastern European regimes that supported them. He published his findings in 1944 in a book entitled Axis Rule in Occupied Europe. And it's a fairly sober work, 700 pages, most of them summarizing or reproducing laws that had been enacted, laws requiring particular minorities not to live here or there, precluding them from exercising certain professions, requiring them to inform about movements and their property status, etc., etc. Much of this is pretty sober. You could say cynically it's the work of a gatherer, not a hunter. But one chapter stands out, and this is the famous 9th chapter of Lemkin's book, in which he steps back from the detail and the technicality and says how the law should respond to this practice that he was mapping. And he begins this 9th chapter with a programmatic line. New conceptions, he writes, require new terms. And he proposed that the practice he had surveyed would be referred to as genocide, sort of a curious mash-up of Greek, genos, and Latin, side, kide. And he said this: by genocide, we mean the destruction of a nation or of an ethnic group. It is intended to signify a coordinated plan of different actions aiming at the annihilation of groups themselves. And here comes the key phrase: genocide is directed against the group as an entity, and while the actions involved may target individuals, they are targeted not in their individual capacity, but as members of the group. That was the distinctive feature, thought Lemkin, of the new practice, which he called genocide. And he said that the law should embrace this, not the practice, but define this as a crime and identify it. You could say it was a law reform proposal driven by agony. What happened to it? Did it have an impact? Lemkin certainly wanted it to be impactful. He didn't write for his fellow scholars. And overall, I think he did have a massive impact. But the first opportunity was only half seized. 1 year after the book was published in 1945, the war had been won by the Allied powers, and they set about prosecuting Nazi war criminals in Nuremberg. And they did so on the basis of the charter of the Nuremberg Tribunal. Lemkin lobbied the negotiators to include genocide as one of the crimes that would be prosecuted. But they didn't agree, and the charter focuses on other aspects: crimes against peace, crimes against humanity, war crimes. Genocide was mentioned in the Nuremberg proceedings and spoken out as a word, and so were references made to the atrocities committed against Jews, but the Nuremberg judgment doesn't speak of that. And perhaps astonishingly, if you look back at it now, in retrospect, as we know how much the Holocaust defines our history of the period, it treated that rather as a collateral of the war. It was a war crimes tribunal that looked at crimes against peace, and genocide may have happened in the course of a war, but wasn't seen as such as the major problem. Lemkin is said to have been stunned and shocked at this omission. After the Nuremberg judgment, things happened very fast. 2 months after the judgment, the General Assembly adopted a resolution in which it declared genocide to be a crime under international law. And it described genocide in the way that Lemkin had described it: a denial of the right of existence of entire human groups. For 2 years, states and experts in the UN prepared a draft treaty against genocide, and on the 9th of December 1948, it adopted the Convention on the Prevention and Punishment on the Crime of Genocide. It's a pretty complicated treaty, not without problems. It defines genocide in a very peculiar way, focusing on the intent of perpetrators who must seek to destroy in whole or in part a group, a racial, ethnic, national or religious group. And this is very difficult to prove, and many people agonize over the problematic definition of genocide. But it's been a remarkable achievement nonetheless. And if you think about the timeline, then it's been surprisingly quick. The convention was adopted less than 5 years after the liberation of Auschwitz, and just over 4 years after Lemkin had published his book and first used the term. Lemkin was involved in the process as an expert and advisor. He was not happy about everything in the convention, and his life probably wasn't a very happy one. He's not a superstar for a glorious movie. He died poor and forgotten in 1959 and was only later rediscovered. But there's little doubt that the Genocide Convention is his legacy, a response to atrocities that needed to be called by their name. A response that was decisively shaped by the work of one single scholar who identified the particular evil of a crime and felt it required to be addressed through international law. So it's a grim story, but I think it's one that shows how scholars as activists can influence the development of international law. Now, more briefly, much shorter and much less grim, my second story. My second story shifts from Poland to Italy. The timing is about the same, mid-20th century, but it involves not prosecutors who would die poor and destitute, but prominent law professors who would have a brilliant career, adored by disciples around the world and referred to as maestro, not only by the Italian disciples, but by the international law world writ large. It's a story of another form of scholarly influence, not that of the activist, but that of the systematizer. And it's the story of Roberto Ago and the law of state responsibility. So unlike with Lemkin, let me tell this story backwards, and I'll tell it in a simplified form, which embarrasses me a bit in Italy, because Italy is the mecca of the study of state responsibility in international law. So the colleagues, please forgive my simplification in the interest of time and storytelling. State responsibility is with genocide, we have an intuitive understanding of what this is. This reaches the headlines. State responsibility doesn't. It's a technical area of international law, but one of the areas that no international lawyer can afford not to know about, at least in basic terms. It's the regime that describes, or that governs wrongful conduct by states. It sets out conditions under which conduct can be considered wrongful, consequences resulting from this, certain avenues towards redressing responsibility, obtaining remedies. It's the equivalent a bit like sort of what in national legal systems might be tort law, delict law, contractual responsibility, all rolled into one. It is set out in the most, if you want, accessible form in a text in 2001 adopted by the International Law Commission that is everywhere in international discourse and considered to reflect customary international law. And it's interesting because it's a framework. It's really only a framework. The state responsibility text defines rules of responsibility, but doesn't solve any individual, particular, concrete dispute. It speaks about general conditions of state responsibility. It's the skeleton that misses the flesh to the bones, because it speaks about questions in the abstract. Under what circumstances is a conduct of an individual attributable to a state? What is owed in abstract terms if a state breaches international law? But it steers clear of, if you want, the key question: what are the obligations of states? What are the concrete duties that states are under? It doesn't engage with the substance of international law. But because it steers clear of that, it is the ILC and others were able to write general rules that are applicable to all breaches. Whether a state breaches a treaty between two states about the delivery of, I don't know, gas against payment, or the commission of war crimes during a war. The idea is that all these breaches have something in common, are subject to a unitary framework that governs wrongfulness and its consequences. Now, what are, I think that is the key insight. You could say that's all pretty simple, or perhaps banal. But if you look back, you see that this is actually sort of a relatively new insight. If you look to the scholarship of the 19th century, even in English law books of the 1960s or 1970s, they didn't treat responsibility as a general category. Of course, they wrote about breaches of international law, but they approached that topic very, if you want, sectorially. They looked at particular areas: injuries to aliens, expropriation, treatment of diplomats. And within those subject matter categories, you would have to look at breaches, consequences, and responsibility. They didn't generalize. They looked at causes of action. Now, you could say figuratively or metaphorically, international law for a long time, and English scholarship for a lot longer, looked to the tree but didn't see the forest or didn't think there could be a forest. Now here comes Roberto Ago, and I'm being told that I should wrap up, so this is very brief now. I would say if there's one person who told us that there's a tree, not just a tree, but a forest, it is Roberto Ago. He was not alone, like Lemkin, but he had a profound influence in designing the landscape and telling us to think of the forest. This was Ago in the ILC, where he wrote the reports that resulted in the adoption of this 2001 text, but also, and this brings me to the point I wanted to make, Ago as a scholar. Ago as a scholar that in 1939 already, almost in parallel time temporarily to Lemkin, delivered a course at the Hague Academy, Le Délit International, in which he outlined the program for a general regime of state responsibility, and where in rudimentary form you have it all there: general categories of attribution, general categories of reparation, general categories of circumstances precluding wrongfulness. We can perhaps pursue this in the discussion to the extent that as Italians you obsess about state responsibility. I will leave it short and finish with one or two thoughts, with apologies for going slightly over time. It's maybe the genius loci again. I will say one thing on Ago. If the ILC's work has, as is often said, encoded the way international lawyers work with state responsibility, then Ago is the chief encoder. He wrote the code, we could say. And if we look at his different productions, then you could say as a special rapporteur, he wrote the main code, but it was all there in 1939. My final analogy perhaps for this, from German literature, if the state responsibility work is Faust, then there was an Urfaust, an earlier version of Faust, which was a scholarly product, a Hague Academy course. So I'll end on this, with apologies, as I said, to Andrea for speaking slightly longer than I should have, by saying that there is room for scholarly interventions that have their impact. Very clearly, these are scholarly interventions that require to be taken up, amplified, and integrated into lawmaking processes. But there is room for that in these two fields that I've outlined: the scholar as a systematizer and the scholar as an innovator who sees more clearly what is urgently required by international law. Thank you very much.
Thank you, Christian. Thank you for this interesting presentation and for the special focus on two big figures in the international law, Raphael Lemkin and Roberto Ago. Now I give the floor to Serena Forlati. She is full professor of international law at the Department of Law of the University of Ferrara. Her current research interests focus on international courts and tribunals, especially on international procedures, international human rights law, and its interaction with international criminal law. Please.
Thank you very much, Andrea. And first of all, let me also thank the organizers, Luigi Lacche, Paolo Palchetti, and Pepe Ragoni as well, for inviting me and organizing this wonderful event. My task is much more mundane than the ones of the previous speakers, or perhaps I have approached it in this way. I will try to sketch out what is the impact today of scholarship by looking at the role of scholarship in the list of sources that is included in the Statute of the International Court of Justice. Article 38 of the statutes identifies the law that the International Court of Justice is called upon to apply when deciding cases submitted to it. And in this list of legal sources, also scholarship in the shape of teachings of the most highly qualified publicists of the various nations is included. I will try to discuss how this wording is to be understood today, keeping in mind what has already been said, namely that international law is changing. The role of scholarship is perceived as fading, slowing down as compared to when Alberico Gentili was active together with Grotius, and also as compared to 1920 when this text was first drafted as part of the Statute of the Permanent Court of International Justice. Already in 1920, this reference to teachings was not included in the original draft. It was something that came along in the discussions within the Advisory Commission of Jurists. It was put forward, the suggestion to insert a reference to the work of jurists and the opinion of writers was put forward by the US and United Kingdom's delegates in the framework of a more general discussion as to the risk of lacunae in international law, the risk of gaps in international law that would lead the new court to be unable to decide on a case or on a specific issue because of lack of an existing legal rule. And in this regard, it is quite clear that such a risk today is much less. Not totally inexistent, but the trends that Christian Tams discussed earlier have certainly led to a much narrower possibility for gaps. And this alone might lead to conclude that there is no role to play for scholarship as such. There are other considerations as well that were already made, but my discussion of the topic would like to give you some insights about some very recent work of the International Law Commission that is dealing with subsidiary means and also with the teaching of scholars in its effort to complete the analysis of the sources of international law. And that is provides some interesting insights as to the role of scholarship today. I should note at the outset that when the International Law Commission discussed the inclusion of this topic, subsidiary means, as we international lawyers call them, so judicial decisions and the teaching of publicists as subsidiary means for the determination of rules of law. That is the wording included in Article 38, paragraph 1, letter D of the Statute of the International Court of Justice. There were uncertainties about the wisdom of looking at this particular source. States expressed fear and concern. Well, the agenda of the International Law Commission is discussed and proposed by the Commission itself, but it then is backed by the General Assembly of the United Nations. And in the discussion about this proposed topic, fears were expressed that this exercise would lead to a possible over-reliance on judicial decisions and scholarly works, and also there were considerations that it might not be so relevant to discuss this kind of topic. At the end of the day, the decision was taken to take up the topic. The Commission began its work in 2021 and is now in the process of adopting a number of conclusions, draft conclusions, as very frequently in the last years, the International Law Commission does not purport to draft conventions or texts that are meant to be transformed or transposed into international treaties, but rather authoritative, non-binding texts. And in this regard, what one might also wonder what the role of the International Law Commission is. This was already mentioned as a possible auxiliary means for the determination of international law. The special rapporteur appointed to deal with this topic is Charles Jallow, and he expressed in his first report the idea that there are aspects of these subsidiary means that need to be clarified, both as to what we understand as subsidiary means and also as to their interaction with the other sources listed in Article 38 and other sources of international law. Because decisions of courts and teachings of publicists are not sources as the others. They are clearly understood within the ICJ statute and also very clearly by the International Law Commission as subsidiary means, as means that help determining the content of international legal rules, interpretation of treaties, identification and of the existence and content of custom of general principles of law, but not as legal sources as such. So this is an important clarification that the International Law Commission also took up in its draft conclusions. There are now 8 provisionally adopted draft conclusions, and one of them points out that this fact subsidiary means are not sources as such. What is also interesting is the fact that the International Law Commission tries to anchor its conclusions on state practice. This is something that was encouraged by states in discussing the topic, but also something that the International Law Commission usually undertakes as a method of work. And there is a request to states to submit their own reports or information about how these subsidiary means, namely case law and teachings, are used at their domestic level. Very few states have answered so far, but only one of them, South Korea, has mentioned that there is no reliance on case law or the teaching of jurists in its domestic judicial practice. Other states such as Sierra Leone, but also the United Kingdom, the United States, Ireland, state that their own domestic authorities, specifically domestic courts, rely on both case law and the teachings of publicists. And I will come back to this later. What is, for me, interesting in looking at the draft conclusions is first that the focus so far has been mostly on case law and less so on teachings. This is also because the special rapporteur has in his plan of work intends to deal with teachings later on in his third report due in 2025. But there is a provision, a draft conclusion number 5, as it is now numbered, dealing with teachings. And in drafting this draft conclusion, the special rapporteur also relied on the work of within previous exercises, the exercise on the identification of customary international law, on general principles, where a reference to teachings was also made. Draft conclusion 5 tells us that teachings, especially those generally reflecting the coinciding views of persons with competence in international law from the various legal systems and regions of the world, are a subsidiary means for the determination of the existence and content of rules of international law in assessing their representativeness. Due regard should also be had to inter alia gender and linguistic diversity. This is how the draft conclusion on teachings is currently framed, and the International Law Commission highlighted that when framing this text, it had in mind the idea that teachings as described and as regulated by Article 38, paragraph 1, letter D, were still relevant as an auxiliary means of determining rules of law, but that the wording in Article 38 was archaic, and that the new drafting was meant to modernize and propose a more contemporary formulation for a concept that should remain nonetheless more or less the same as in 1920. What is also worth highlighting, in my view at least, is the fact that in other provisions of these draft conclusions, teachings and case law are put more or less on the same level. In one of the commentaries provisionally adopted, there is a reference to the fact that there might not be a perfect equality between the different subsidiary means, but still teachings are put more or less on a par with case law. Even if, as was mentioned earlier, case law now seems to have a much heavier impact on the development of international law than teachings have. The function of case law and teaching is the same as highlighted in draft conclusion number 3, and that is to help determining the content of international law. And also, the criteria that are suggested in draft conclusion number 3, in order to identify the weight to be given to those to those auxiliary sources, are the same for teaching and for case law. These criteria are now listed in conclusion number 3, which identifies 6 criteria: the degree of representativeness of the auxiliary source, the quality of the reasoning, the expertise of those involved, the level of agreement among those involved, the reception by states and other entities, and where applicable, the mandate conferred upon the body. So I find it interesting that criteria adopted and very often relied upon in order to assess the weight of case law are also employed for assessing the weight of scholarship. Because, as was earlier recalled, scholarship is much less explicitly relied upon than case law. Whenever decisions of judges of international judges are at stake, but also in other contexts. Still, we do have situations where scholarship is officially and formally quoted, scholarship is taken note of, and how does it happen that particular authors, specific authors, get to this kind of stage? Christian Tams earlier referred to 2 prominent examples of the 20th century where scholarship really managed to shape the development of international law. On both occasions, it was a case of great scholarly devotion, one could say, but also of the possibility of the outcomes of the scholarship to gather a broader audience. A scholar can never shape international law on its own, no matter how high the level of its wisdom and scholarship as such. The attempt by the International Law Commission to rationalize how scholarship manages to get on the stage of international law is in itself useful, although I personally feel that it is always very difficult to give weight to one or the other of these 6 criteria, and there are probably more. There is often a matter of opportunity, of sheer luck, of being in the right place at the right moment that is very difficult to grasp into a specific generalizable criterion. At the same time, there is one aspect of these list that particularly intrigues me, and I will try to explain why. This aspect is the one listed in letter E, the reception by states and other entities. At the end of the day, scholarship manages to shape international law if it manages to be received by relevant actors. And of course, the quality, the authoritativeness of the authors is key, the quality of reasoning as well, the expertise, the fact that there is a representativeness of the body. I think Attila explained us very well why a body such as the ILA or the Institut de Droit International manages to play a greater role than individual scholars in shaping international law. The sheer fact that it is a collective body and that its representativeness is ensured by the way in which the body is set up is in itself a help in demonstrating that it is an authoritative work, that it is not biased, that it is not the reflection of specific interests, but it has managed to sort of be swifted and through a broader discussion. And it is no surprise that it is precisely the work of these collective bodies that gives a broader audience even to individual scholars. I would like to quote here a short passage by Alain Pellet in his commentary on Article 38. He writes that it is perhaps very good that the International Court of Justice does not often rely on scholarship in its decisions. This is really something that varies a lot among international courts, and international courts in their decisions rarely quote directly scholarly work, as Christian has also recalled. But Alain Pellet, through the lens of his broad practical expertise also and his scholarly appreciation, writes that the intrinsic scientific value of the doctrine is extremely variable, probably as much as it's the exploitability of the work of scholars who quite often take delight in abstract discussions which can only be of little help in the adjudicating process, and this is one problem. But there is also another problem that he very rightly points out, namely the fact that most well-known publishers come from the global north, and more particularly, he says, and I quote, from a handful of countries where international law has gained a rather high degree of sophistication. Too much emphasis on the teaching of publicists by the court would unavoidably throw light on this unfortunate situation, while at the same time showing that different nations, in principle required by the text of Article 38, paragraph 1, letter D, are not so different. So this is a problem when international judges rely on scholarship. Relying on the work of learned societies, as the ones Attila dealt with, is somehow a safeguard against this risk of being viewed as biased and taking up only the reasons of some. At the same time, I think that the key to reception by states and other entities is broader than that. There is not only a problem of representativeness. There is also the fact that scholars sometimes, very luckily, manage to meet some need that comes from international law and the formal actors in the international legal sphere. Needs of systematization, as Christian said, needs to innovate. And when they manage to capture the attention of those needing to systematize or to innovate, that is when they can get to gain an influence. Of course, all the other elements mentioned by the ILC in draft conclusion 3 are relevant, but I think they are relevant because of the ability to gain this reception. And reception by who? Definitely by states, as Christian has also mentioned, they still remain the main actors at the international level. And in this respect, I find it interesting that Ireland, in answering the survey by the International Commission, not only identified elements of domestic case law, quoting international case law and scholarship, but also referred to its own use as a state of scholarship in its pleadings before international courts. The fact that a state relies on a certain piece of scholarship is in itself an indication that that piece of scholarship may be useful to the state. Of course, when it is an international court quoting that piece of scholarship, this has more momentum because of the impartiality of the assessment that the relevant court has made, and that gives a heavier weight to the reference, I think. But it is also other actors, NGOs, civil society, international organizations that may be, rely on scholarship in order to put forward their ideas and agendas. And maybe in this light, we could also say that the use of scholarship today in shaping international law gives also us a glimpse about the change in international law and its whole overall structure. Not only a world made for states, but a world where other actors also have a role to play, and their use of scholarship is also impactful in the way in which international law is shaped. I will stop here, and thank you very much for your attention.
Thank you very much, Serena, for your presentation. And now we have a small space for questions. So I invite the public. Please, we can collect 2, 3 questions, and then we can go the floor to our speakers.
Thank you very much. And I have the same question to all 3 panelists, if you don't mind. What about teaching in the singular as part of your stories, so not teachings? Professor Tanzi's article, which I greatly look forward to, that relies on empirical evidence concerning the impact of the ILA, reminded me of Anthony Roberts' study of textbooks, which, and of course, Professor Koskani has written about this extensively as well. The extent to which textbooks influence the scholarly institutions and their efforts to influence public international law. I was wondering if such empirical evidence can be collated somehow to get a more holistic assessment of these institutions' impact. Professor Tams gave us 2 vignettes of an activist and of a systematizer, and of course explained that Ago's source was a course of lectures at The Hague. And I was wondering if someone like James Crawford's textbooks, his extension of Brownlee's, for instance, might give us a 3rd type of vignette that would fit into the same story. And Professor Forlati has raised the very important question of how can possibly some scholars succeed in becoming sources of authorities, which again seems to point towards teaching as one possible activity. Crawford could be an example again, whose textbooks are cited by various parties who were seeking to influence his decisions after he had become an ICJ judge. So teaching in the singular is my question to all three panelists. Thank you.
Do you have any question?
I suppose we are going to answer in order. Individual teaching textbooks. Now, from my research, it looks, and it's pretty obvious, that some scientific conclusions can be drawn and shown and evidenced when you have manifest data. I mean, footnotes, quotations. But these apparent manifest means of research, which can also fit newly developed computational methods of analysis, I think are not faithful to the actual reality. We just saw it this morning discussing the fact that more often than not, the ICJ particularly takes into consideration, relies on authorities that it does not quote. But my take is that when the court upholds an argument that has been pleaded by counsel who has relied, substantiated by relying on given authorities, and eventually has persuaded the court to go by his or her argument without really quoting it, by implication, indirectly, has been persuaded. I mean, authorities are there for persuasive purposes, unless we talk about authorities as sources of law. So you can take all these indirectly to mean that the court upholds some kind of legal thinking that is being presented by counsel. And this, obviously, with regard to quoted authorities, but also the legal thinking of counsel. He is learning throughout decades, is there, as much as it is there in the actual sitting judge, which is very difficult to prove, analyze, evaluate computationally. It's invisible, magically invisible. And in that respect, I think that the point made by Serena is that it's very much Western-oriented so far. But thank God there are more and more leading scholarly actors taking major role, coming to the fore, that do not necessarily come from La Sorbonne or Heidelberg or Cambridge or Oxford or Macerata. Second, yes.
Okay, thanks. So one word about, well, a few words about teaching and textbooks. I think, I'll speak from a British experience where the focus is away from teaching and textbooks and on research, innovative, changing research. That's what we're meant to do as academics in Great Britain. And if you write a textbook that sells 10,000 copies, that's not considered relevant research. And I think in response to that, I would say I probably agree that if we're looking at the impact of the work of academics, then I think teaching and textbooks are probably the far wider, certainly, impact. I remember sort of towards the end of their careers, professors sometimes may say that, yeah, all these funny articles that they obsessed about were good, but what they left were sort of widely read books and they have 100 people that they recall that sat in their lectures and they carry on the baton. So I think that's a sort of slightly apropos of nothing, but perhaps apropos of elements or subtexts of your question. So I think if we're looking at influence of academic work, then I would say teaching and by extension textbooks can be massively more relevant than other forms of academic output. You asked about sort of maybe one more point for textbooks. Of course, I think the gatekeeping and categorization function is key, that through widely read textbooks you define perhaps not the sort of the, let's say, the development of law in a particular field, but the understanding of the discipline, and that's for that textbooks would be key. But you really asked me about a potential third vignette by a scholar that is familiar to many, certainly the international lawyers in the audience, James Crawford, and you asked about an updating of a textbook. Would that have lent itself to a third vignette? I think my short answer would be no, because I felt it made an enormous contribution to the understanding of the discipline and perhaps salvaged a textbook that had become eccentric before and retained relevance. But I don't think it was written with what I had in mind, a targeted intervention that thought to shape the development of international law in a particular field. So it was more a stock taking, a general account, and as such, very valuable, but it would have been a third vignette that would have stood slightly ajar to the ones I had in mind. So I would have looked at, I don't know, had I had more time, then I might have looked at, I don't know, Cassese, or let's say more targeted, more openly, sort of more academic work that is more openly written with a view to changing practical discourse. And I wouldn't put James Crawford, notwithstanding the respect I have for him, I wouldn't put the Brownlee textbook that you mentioned in that category. Thank you.
Since there are a few questions, can I add a gloss before passing the floor to Serena? At teaching scholars, professors of international law, their authority and their relevance, I want to share with you some changing indications. Yesterday we talked about neutrality of academicians versus political choices. And what I notice is that there is an increasing relevance of scholarly works in international judicial practice, developing the branch of international law bearing on international procedural law. To an extent unknown 20 years ago, you even had a branch of the Max Planck Institute in Luxembourg that devoted its existence to the study of procedural law. And courts and tribunals, as I already anticipated in my presentation, quote scholars with regard to procedural law. McNair, Gerald Fitzmaurice, Shabtai Rosen, Gaetano Morelli, all devoting their thinking to actual, rather fastidious, precise, or more or less precise area of international law, because it's less ideologized and requires filling gaps. But when I say that, what I notice, and this is maybe in line with what Christian tried to counter, the diminishing relevance of scholars in the old sense. What I notice is that there is an upsurge of relevance of apparently scholarly writing by non-scholars, particularly in the Anglo-Saxon world. You learn a lot as a professor listening to presentations by practitioners like Sam Wordsworth, Michael Wood, Daniel Bethlehem, and the rest of them, Amy Sanders, Ben Juratovich. And they do not write only on international procedural law, but the interest that is focusing on international law is that, I don't know, international law is becoming less and less an area where you really discuss the legitimacy of the international use of force. And that remains in the hand of the mighty and the states. Sorry. So it's sort of a self-withdrawal.
I will start by saying that the ILC, not only in its work on subsidiary means, but also in the other occasions in which it addressed the role of teachings, did stress the fact that teachings are not only research or written contributions, also lectures, also conferences, materials that are not necessarily written can amount to teachings. Audiovisual, for instance, intervention or contributions. So there is a broad approach to what teaching is in the framework of this particular discussion. And I think this is very much appropriate. It is not only scholars that deal with international legal issues today. We also face a situation where scholarly discussion is run first and foremost on podcasts, on blogs, on Twitter, and then maybe much, much later it comes into more traditional venues such as articles in journals or textbooks. But I think that there is another consideration to keep in mind in order to try and answer your question. That is that professors, or in any case scholars, have the opportunity to shape through their teaching in the sense of not written works, but their actual teachings or textbooks, they shape the mindset of those who actually make international law as practitioners later on. And this kind of impact is very difficult to measure, but it does give you an idea of why certain ideas come through. It is also because a certain mindset has been disseminated through teachings in key scholarly and institutions and universities. The Hague Academy, why wasn't Agos able to spread his ideas? Also because he was invited to teach at the Hague Academy. And the kind of audience a scholar at the time could have, and even today probably, through the Hague Academy could never be achieved at the national level. So I think teaching is key to understanding how international law is shaped, also in this particular perspective, textbooks and other kinds of teachings, less traditional ones.
Other questions? Well, I think that we can close this session. Thank you so much to all our speakers for accepting our invitation in this conference. And now we can take a little coffee break. And so I invite you to join in the room near close to this.